So it's all yours.
Great. Can you all see my slide?
Yes.
Okay, great. First hurdle crossed. So I thought that I would start by telling you a little bit about how I came to be here talking about adult guardianship. And then I wanted to know from you what brought you here, if any of you have experience with guardianship. And then we'll sort of walk through the basics. So I have 11 slides, and I hope that those 11 slides can cover all of the basic aspects of what we know as guardianship. So as Gary just said, and as Cheryl said, I worked for the American Bar Association, Commission on Law and Aging, actually from 1980 through 2020, and retired right into the pandemic. But in a lot of that time, I did spend on adult guardianship and related issues such as healthcare decision making. But I wasn't done with guardianship. It still intrigued me, and there were many objectives that I wanted to accomplish. So I have been consulting on guardianship issues throughout the last 5 years, actually on some very interesting projects throughout the country. So I wondered what brought you all here, and if there's anyone here that has had a personal experience with guardianship. Anybody want to respond to that? If not, that's okay too.
I have a number of neighbors at the Jefferson that have guardians, and so I'm concerned and interested in how to help them.
Oh, hi, Link. Very good
Yeah,
to see you. Thanks. And I'm not surprised that you have neighbors in the Jefferson who are subject to guardianship. That's a very, very good example.
I
So
have
yeah,
oh,
anyone
sorry.
else?
Yeah, I my sister, I do not have guardianship or power of attorney, and as she gets older, she's having more and more physical difficulties, but she's sort of paranoid, so she won't get help for herself. So I'm trying to learn more about guardianship.
Great. Well, your timing is good because now is the time to think about it rather than waiting until there's a crisis. And thanks, Liz. I worked with Liz. Liz worked with me at the American Bar Association, so that was a great connection. So let's start by looking at what is this animal called guardianship? What do we mean by guardianship? So here is the basic definition, and I'm going to read through it and then tell you what to sort of mentally circle in your mind. So guardianship is the court appointment of one person or entity to make personal and or property decisions for another person whom the court finds unable to make such decisions for themselves. So what's important about that definition? Well, you'll see I've italicized the word court. So this is a court appointment. You might hear some people say, oh, I'm the guardian for my brother, by which they mean I sort of look after him and take care of him. Not, that's not the legal definition. This is very much a court process. And it's a process that revolves around decision making. The guardian who is appointed by the court is appointed to make decisions for another person, another adult. And those could be personal decisions such as where to live or what medical treatment to have, or it could be property decisions such as whether to enter into a contract or sell a house or other property. And then this other person is a person whom the court finds is can't make those decisions for themselves, technically known under the law as an incapacitated person. But because that term is sort of, I feel, not the best of terms and sort of discriminatory, I just refer to them as the person subject to guardianship. So examples of decisions, as I just said, that might be made by the guardian are medical decisions of all kinds, ranging from minor things such as whether to get a flu shot to major things such as whether to have surgery or seek mental health treatment or something like that. residential decisions, whether to go into assisted living or nursing home, and financial decisions, what to do concerning your property, your finances, and whether you are eligible for any public benefits. Now, I want to say a word about terminology, and this is interesting because guardianship terminology differs by state. So it makes it very hard to talk about it on a national level. Um, Here in Virginia, we use the words guardian and conservator. And guardian means someone appointed by the court to make personal and residential decisions, healthcare decisions for the individual, whereas conservator is someone appointed by the court to make money and property decisions. But in other states, it's different. For example, you probably remember the Britney Spears case that was all over the paper several years ago, and they talked about her father as the conservator. They did not mean that he just made decisions about her money. No, he made decisions about everything, including her birth control and family visits and everything, because in California, conservator refers to both personal decisions and property decisions. That's just an example. And by the way, if you have questions, let's try to do those as we go along. If that doesn't work, we can hold them to the end, but I think it's more of a conversation if we converse.
Well,
Um,
Erica, we do have one question already.
okay.
Um, what's your opinion on supported decision making as an alternative to guardianship? And she's specifically concerned about a learning disabled 27-year-old that she knows. Can you
Um,
explain what that term means?
I can, and that's tucked in here toward the end of the presentation, but I'll say a word about it now because you've touched on a very important topic. So when people appoint let's say a financial somebody to be financial power of attorney, or when they make a healthcare directive, they are appointing somebody to make decisions on their behalf. So they're appointing a surrogate, I'm appointing somebody to make my decisions. But supported decision making is a paradigm shift whereby individuals are empowered to make their own decisions with support. So they arrange with supporters, trusted supporters who could be family members or others, to help them make their own decisions, um, and they can write that down in an agreement known as a supported decision-making agreement. Here in Virginia, the law provides recognition for supported decision-making agreements for adults with developmental or intellectual disabilities. That doesn't mean that others can't make those agreements, but that is the specific provision of the law. But we'll circle back to that. And thanks for that very good question. Um, but back to the basics here. Who are the guardians? Who is that person or that entity that the court might appoint? Most of them are family members. So you might hear somebody say, I'm the guardian for my mom, for my sister. Um, but in some cases, they could be friends, they could be neighbors, they could be colleagues. All of those are what what we know as lay guardians. In other words, they're not professionals. They're people who want to help somebody. Here in Arlington, we have a volunteer guardianship program. So we actually have some volunteers who have stepped up and said, this is a really important role, and I want to volunteer to do that. Um, but in some cases, the court will appoint a professional. Here in Virginia, the professional that the court usually appoints is an attorney. So many, especially elder law attorneys, serve as guardians, or it could be a probate, trust and estate attorney, step into that role and serve as guardians. They're what we might call a stranger guardian because they haven't known the person all their life like their family has, but they can perform the needed decision-making, property management, healthcare management roles. It could be an agency, a private nonprofit agency, or even a for-profit agency, although we don't have many of those in Virginia. And finally, it could be a public guardian under the public guardianship program. And we have a very fine, wonderful public guardianship program statewide here in Virginia. Not enough funds, of course, but we're working on that to enhance that. So I'm going to move along unless anybody has questions at this point.
One question that's come up is the guardian financially responsible for the person under guardianship? For example, as if her sister loses her housing subsidy, it would put a severe strain on her to try and keep her where she is.
Yeah, excellent question. No, the guardian is not financially responsible. The guardian is responsible for doing everything that the guardian can to maximize the resources and apply for public benefits, but the guardian is not financially responsible. So, and in fact, it's very important for the guardian to keep their finances separate from the individual that they're serving. So there are lots of responsibilities, and I'll go into that later, that a guardian has, but financial liability is not one of them. It's a very important question. So who might need a guardian? Who are we talking about? Well, what you often hear of is adults with dementia, maybe Alzheimer's or some other kind of cognitive impairment, who are mostly older adults. Might be a younger adult with a developmental or intellectual disability. It might be an adult with a traumatic brain injury. Someone's been in an auto accident and needs a guardian, hopefully temporarily, because those with traumatic brain injuries often recover quite well, even though it might take time. But in the meantime, they might need a guardian. It might be an adult with serious mental illness who needs help in decision making. And usually it's adults with some combination of the above. So it's not just one thing. And finally, it's also transitioning youth with developmental disabilities. So, you know, a young person, say in high school, is the parents is not an adult under the law, and parents are responsible for making decisions for that person. But once the individual turns 18, they can make their own decisions. So if they're unable to do so, and the parents want to continue to make those decisions, they may request to be appointed as guardian for that transitioning youth. But there are also, as we just talked about with supported decision making, there are also lots of other options. Okay, so that's who we're talking about. So I thought you might like to, if you've seen one guardianship case, you've seen one guardianship case. They're all different. And I wouldn't attempt to say that one represents all of the dynamics. But this is one that derives from a real case, and that we took from a writing. I was with my colleague writing an issue brief for the National Center on Elder Abuse, and this was the example that we used. So in this case, Gloria is an 86-year-old widow with heart failure and dementia, and she lives at home with her son, Philippe, who's 50, who's unfortunately unemployed and a heavy drinker. But she doesn't have anybody else in the area, and she relies on her son to shop for food, keep the house clean, and drive her to the doctor, and so on. So she does have a daughter in another state, though, who recently visited, found her mother malnourished, disheveled, and confused. The home was messy, the bills hadn't been paid, and the ATM card was missing. Philippe denied any problems. Enraged, Sonia, the daughter, filed a petition with the court for guardianship of her mother. So as I say, that's just one story in, hundreds. But it is one that Adult Protective Services often sees in various iterations. So that's the kind of thing that might trigger guardianship. Often it's triggered by a crisis. Somebody may fall on the floor in their home, be rushed to the hospital. Once they get into the hospital, they seem confused, unable to make their own decisions. The hospital, in a need to make decisions upon discharge, applies for guardianship. A guardian is appointed, and that guardian then may make it possible for the individual to return home with services and supports, or may work on the admission for that person to assisted living or a nursing home. So that's another scenario. We do have what we call the hospital to pipeline guardianship, where if that happens, if individuals end up in a confused state in a hospital, that happens so frequently, and the hospitals so frequently apply for guardianship that it kind of becomes like a pipeline. So that's something that needs further look. So let's see here. Move on. Okay. So we've used this word guardian a lot. But what we want to look at now is, what does that actually mean? And somebody brought up the question of, does that mean you're financially liable? And the answer is definitely no. But it is a very challenging role. It's one of society's most challenging roles. Sometimes I think of it as sort of a Superman. Superman, on the shirt, you see super guardian, because what the guardian has to do is provide for the adult's safety while at the same time respecting the adult's values and abilities. Now, that's really a hard thing to do because you're walking a very fine line. You want to make sure this person is safe from harm. But at the same time, you want to hear what the individual says, what is important to the individual, not just what is important for the individual. And you want to dig deeply and find some way to accommodate both of those sides. It's kind of the classic ethical conundrum of autonomy versus beneficence, rights versus needs is very hard to do. Now, not all guardians do it that way. Some just say, well, I'm gonna admit him to a nursing home, and they don't go that extra mile, but that is what national standards provide that guardians should do. Guardians should plan for and monitor the adult's care, again, listening to the voice of the adult. Determine the adult's living arrangements. So the guardian is the one that's going to look at the quality of care of nearby nursing homes and assisted living, look at the finances that are needed, and make those kinds of arrangements. The guardian is going to manage if the guardian is also the conservator, and they could be two separate people or the same person, the guardian is going to manage the adult's money and property. And finally, the guardian is going to report to court. Every year, the guardian must fill out a report, which goes actually in Virginia to Adult Protective Services and is eventually sent to the court. And on the conservator side, the conservator submits an accounting of the money, what money came in, how was the money spent, how does it all add up? And that goes to somebody appointed by the court called the Commissioner of Accounts, who looks at the accounting and reports to court. And then just this year, thanks to recent legislation, all guardians, and I mean all guardians, including family guardians as well as professional guardians, both guardian must, and we're talking here about guardians, not those who are just conservators, they must take training, and there's an online training for guardians. So that's a big step forward for Virginia. The most important thing to remember about guardians is that guardians are fiduciaries. Now, that word fiduciaries, what that means is that's one of society's very highest standards of trust and confidentiality, honesty, So guardians have a big responsibility to live up to. Very, very challenging. So, any questions at this point?
Yeah, we've got several questions. This first one's from somebody who has an attorney that created a trust and is power of attorney. Should they also get them appointed as a guardian, or should they seek a guardian from the Agency on Aging at some point when they're less capable?
Probably not. The whole idea, or one of the ideas of a financial power of attorney and also a trust, is to avoid guardianship. So, guardianship is a last resort, as I'll get to in a minute, because it removes basic fundamental rights. So, the idea of planning ahead is to avoid guardianship. Now, that's a great idea, but it doesn't always work because for two reasons. One, you may need to make decisions that are outside of the scope of the power of attorney, in which case a guardian, possibly a limited guardian, may need to be appointed. Or, sadly enough, the guardian may not be um, fulfilling his or her duty and may not be really qualified to be guardian, in which case may not be qualified, sorry, may not be acting up to what a power of attorney should do, in which case the court will revoke the power of attorney and appoint a guardian. But hopefully not. You want to avoid guardianship, not seek it, unless it's absolutely necessary. And we'll circle back to that. Any more questions?
Okay, if someone wants to be a guardian, do they need to hire an attorney to prepare the paperwork and petition the court and all that, or how does that
Okay,
actually
perfect.
work?
Perfect timing, because right now we're going to talk about the guardianship process. But I'll say up front that it is complicated and there is paperwork, and most petitioners, that is, a petitioner is somebody who is asking the court to appoint a guardian. The petitioner could be asking the court to appoint themselves, appoint me as my mother's guardian, or appoint a guardian, and it's not me, but it's Susie over here. So the petitioner is usually represented by an attorney, but sometimes they're pro se, they represent themselves. But it's probably advisable, particularly if it's a complicated situation, and certainly if you expect it to be contested, for the petitioner to hire an attorney. And there are many elder law attorneys and trust and estates attorneys. We're very lucky here in Arlington that we have a lot of excellent attorneys that do that. So a petition, that is a petition is a request for court. Okay, you're asking the court to do something. Court, I want you to appoint a guardian. So that's the first thing. The petition, the filing of the petition will begin the guardianship process. After that, notice must be provided to the person who's said to need a guardian and to that person's family. And that's a very specific thing. The notice must be served personally on the individual. That means that somebody has to go and give that person the written notice. The written notice must have a warning in big type that says, warning, a petition has been filed. This might remove your basic rights. You have rights during the hearing. This is what they are. So notice is very, very important. And then the court will appoint an attorney known as a guardian ad litem. Now, that's a very legal term, guardian ad litem. Sometimes people refer to it as a GAL. So a guardian ad litem is basically a court investigator. A guardian ad litem is the eyes and ears of the court. So the judge can't go out and go to the person's home and interview them and talk to them and look around the home and see what is needed and what the strengths and weaknesses of the person are. So the court sends out a guardian ad litem to do that, to investigate, to be the judge's eyes and ears, and to report back to the court. And it's tricky because that word guardian ad litem sounds like the guardian sounds like a decision maker, but the guardian ad litem just is an investigator and reports to court and does not make decisions. Now, here's where it gets trickier too, because the guardian ad litem is an attorney, and some people might confuse that with having counsel to represent the person said to need a guardian, which we call the respondent. It's very important for the respondent to have counsel to zealously represent him or her, to represent their wishes. The guardian ad litem doesn't do that. The guardian ad litem tells the court what he or she thinks would be in the person of the best interest. Like, I think this person needs a nursing home. But the counsel will talk to the person and find out. The person might say, no way am I leaving this home. No way am I going to want to be in a nursing home. And then the counsel will represent that person in court. The guardian ad litem is tasked with finding out whether the individual wants to be represented by counsel, can hire counsel, or whether, if the person doesn't have the funds to hire counsel, the court will pay for counsel. I know it's a little bit complicated, but that's is a very important issue. In some states, counsel is appointed automatically. Not here in Virginia. We have a guardian ad litem. Hope that makes sense to everybody. So another important element of the process is a capacity assessment. And that is some kind of clinical or healthcare assessment. And that could be anywhere from a one sentence letter from the family doctor who says, this person needs a guardian, this person has memory problems, needs a guardian, can't make decisions, to a long form that might be filled out by a neuropsychologist or somebody with deep psychiatric background. So it's a whole range, but there's some kind of assessment of the individual's ability to care for him or herself and make decisions. And then there will be a court hearing, and that could range anywhere from a 5-minute affair where the judge looks at the evidence and appoints. It's not contested. The court simply appoints the guardian, and that's the end of that. Or perhaps it's a contested case in which the person is saying, wait a minute, I don't want a guardian. I don't need a guardian, and I'm going to fight this thing. Person has their own counsel, and those kinds of hearings could go on for days. It's pretty rare, but it could happen. So the court hearing is very important, and it's important that the person have the supports they need to participate in that hearing if they want to. Some people want to be at their own guardianship hearing. Some people don't want to be there. There are all kinds of different opinions about whether this is helpful for the judge to see and talk with the person, whether the person should testify, and so on. So there are all kinds of hearings. After the hearing, the court will write an order. Usually the order is actually written by the petitioner's attorney, but the order will be written and the court will sign it. The order might be what we call a plenary guardianship. That means the guardian makes basically and it might be for guardian and conservator, basically all kinds of decisions. Or it might be what we call a limited order, where the order says, you still have the capacity to make decisions about where you live, for example, who you want to visit, and so on. But you don't have capacity to run your business or manage your investments. So it could be limited in that way. And then finally, the guardian must submit an annual report, and the conservator must submit an annual accounting, and that goes on for the entirety of the life of the guardian, which could be years and years and years, basically, usually for the rest of the person's life, although it's rare, but it is possible that someone could be restored to capacity. Questions at this point.
Yeah. Erica, which court handles these guardianship cases?
Okay, we're talking about the circuit court in Virginia. So the circuit court, and we in Virginia, as opposed to some other states, we don't have what we call probate courts that would specialize in guardianship, conservatorship, and probating wills and trusts and estates and so on. We don't have that, but we do have in the larger circuit courts. In the more urban areas, we have some judges who have over time gained a fair amount of expertise in the guardianship process. So that those are circuit court judges.
Another question, what is the role of a special needs trustee and power of attorney if it's different from a guardianship?
Okay, so what did you say? A special needs trustee, and what was the other one?
Power of attorney?
Oh, a power of attorney. Okay, so back to the first word in this entire presentation. Remember what the first word was? Court. Okay, so a power of attorney is not appointed by the court. A power of attorney is appointed by the individual. So I want you to be my power of attorney. I am appointing you to carry out these tasks when I'm no longer able to do that. Very different from a court appointment. Now, special needs trust, there'll be a trustee. Now, some trusts are under the supervision of a court, but that's not the same as a guardianship. So it's very important to know the difference. And hopefully the power of attorney and the special trustee will obviate the need for a guardian. There won't be a need, but in some cases there might be. Okay. All right. So I'm going to look, we've been talking about whether we've been talking about how the court appoints someone who might need a guardian. Well, need a guardian? What does that mean? How does the judge, the circuit court judge, make this outrageously difficult decision to decide if somebody else cannot make their own decisions? That's really a challenging thing to step in like that and have to make that decision. So I've copied out the code for you here. And so when you look at the code, it's a lot of words, but the first words, go to whether the person is incapable of receiving and evaluating information to respond to people, events, and an environment. So that's cognitive. Is there something in the person's brain? Have experts said that this person has a cognitive deficit such that they can't receive and evaluate information properly? But that's only one part of it. The second part is down in 1 and 2. To receive an information to do what? Well, to meet their needs for health care, safety, and therapeutic needs, and without the protection of a guardian, or to manage money or financial affairs. So that's what we call functional. What can the person do and not do for him or herself in society? Can they meet their own needs? Can they come up with a plan for their own care? Can they abide by that plan? And it's important to realize here that, and there's also a specific provision in the Virginia Code that says poor decisions, we're not talking about whether the decision is a poor decision that you or I might not make. So for example, maybe somebody decides they want to live on the streets, they want to be homeless, and they've done that for 20 years, and by golly, they want to keep doing that. And they can tell you exactly why. A poor decision, although we might consider that a poor decision, that's not what is meant here. What is meant is whether the person is cognitively and functionally unable to make those decisions. And the third leg of the stool here would be the diagnosis. So the judge might get the statement from the doctor that says so-and-so has Alzheimer's, or so-and-so has schizophrenia. We're not talking about a diagnosis here, although the court takes that into account. But this is not based on some medical label. It's a very functional definition. So a person with dementia, obviously we all know that there are many stages of dementia. A person with schizophrenia or some other kind of severe mental illness might be on medication and might be able to make decisions. So it's not the diagnosis per se that we're talking about, although there's often it's often in alignment. So I hope that makes sense. These are all difficult concepts. Questions at this point?
No, I don't see any new questions.
Okay. Okay. So here we have the many faces of guardianship, the good, the bad, and the ugly. And this gets back to what I was talking about before about the difficult line that a guardian must walk. So somebody early in my guardianship career asked me, Ms. Wood, is guardianship a good thing or a bad thing? And the answer, of course, is yes. Yes, it's both. It's a good thing because it protects the person from harm, particularly in crisis situations. There's, nothing more important in a crisis than having somebody who can come in with armed with court authority and make the decisions that need to be made in order to protect that individual. But it's bad. At the same time, it's considered, according to the law, as a last resort. And because it removes basic fundamental rights, like the right, doesn't always remove the right to vote, the right to contract and make one's financial decisions, the right to decide where to live and how to spend one's money. So all those fundamental rights are usually, depending on the scope of the order, gone. So guardianship, a long time ago, the Associated Press wrote a famous expose and report on guardianship back in 1987, in which they said that guardianship unpersons the individual. Think about that. You're no longer a person under the law, although you do retain some basic rights like the right to respect and dignity, that type of thing. And then we get the ugly. So we know that most guardians, like I said, are super people who are very dedicated, caring. They go out of their way. Most of them bend over backwards to care for the person that they're assigned by the court to protect. But some unknown number, and we don't have data. I once worked on a national project to try to find out, look, why don't we have data on guardianship abuse? Why don't we know? And there are many reasons why we don't know, but some unknown number do take advantage of their position of trust. So they take advantage of the very person that the court has appointed them to protect. And there you see the picture of the Free Britney movement, which brought all this to a head in the press some years ago. In which case her father was both was in California conservator of property and conservator of person, made a whole range of decisions for her over a 13-year period. So that is definitely the ugly. Here in Virginia, we haven't had too much of that type of expose thing, but we did have, I don't know if any of you remember, but back in 2019, there was a series in the Richmond Times-Dispatch about basically it was about the hospital pipeline, how hospitals would get folks, and just attorneys would come in, and there was a pipeline to nursing homes, which were often of very poor quality and sometimes managed by some of those same attorneys who were serving as guardian or who were petitioning for the guardianship. So things can get ugly, but often there, as I said, most guardians are very dedicated. So whoops, let me go back. Okay, I love this slide. This slide, which is called the circles of decision making, was basically created, I sort of copied and tweaked it a bit, from a famous bioethicist, Nancy Dubler, who wrote about decision making and ethics. And so it's the circles of decision making. So you start in the middle and you see yourself in the middle. You are the person. You're a person. You're a person who wants to make your own decisions. You want to decide where you'll live, what you'll do in the future, who you want to see, what you want to eat, and so on. And that's, we all want that. But if you can't, then perhaps you move into the second circle. Perhaps you have enough support so that you can make those decisions. Perhaps you have the help that you need to make the decisions. But if you don't, then you go into the third circle. Perhaps you have already in advance chosen others to make the decisions that need to be made, either on the financial side, like a financial power of attorney, or on the healthcare side, like a healthcare advance directive. And that would often be sufficient. But if you didn't, if you don't have those advance planning documents, then you go to the next circle, in which for healthcare matters, not financial, the families under the law, known as the healthcare surrogate law, the families can make at least certain healthcare decisions. But what if you don't have a family, or your family, or your family member is the very one that's abusing you? Then you move to the very outer rim, the way out in the periphery, the courts decide. And that's said to be a last resort, because the court doesn't know you. The court doesn't know what's important to you. The court may have a press of cases, 60 or 80 cases, and you're just one. The court has only a certain evidence before it and may not make the decision about who should be your guardian that you would want, or what the guardian should um, emphasize. So, and what the plan of care should be. So that's at the very outer perimeter. So you want to do everything you can to avoid guardianship. So here we come to the last slide, which I actually think is the most important slide. And this slide could be a whole presentation, and should be in and of itself. So this slide asks, is there a better way? Are there other options, what we know as less restrictive options? And so just in a nutshell, and there are more fine-tuned options. We can go into much greater depth, but first, the person might have a range of informal supports and services, so that a guardian, they're just, the decisions don't come up because the person's not subject to harm. Maybe the person's in a wonderful, supportive, assisted living environment, and the person has a whole network of friends and family, and things are good. The family helps them make decisions, and it works. Then are legal documents that provide for healthcare decision-making options. So we're talking here about an advance medical directive. And so that medical directive might appoint somebody to be your healthcare proxy, and or it might not only appoint the person to be your healthcare decision maker or your surrogate, but it might be instructional and might give instructions to that person as to what's important to you medically. Like, I want to avoid these kinds of medications. I want to use alternative health procedures when possible. So you might give tips as far as what your wishes are to your healthcare proxy. There are also a whole range of financial decision-making options, financial power of attorney is the most common. And that is what we often call a double-edged sword, because oftentimes people can, quote, get a power of attorney over, quote, over somebody to, quote, make their decisions. So that's the wrong way to use a power of attorney. And a power of attorney should only be given to somebody you trust. So somebody doesn't get a power of attorney over somebody. Instead, you turn it around and you appoint somebody as your agent under power of attorney to make certain decisions on your behalf when you cannot do so. So it's definitely, there's a strong element of trust there. You might, particularly for a large estate, um, use a trust that does cost money to put in place. So it's usually used if there's a large estate. And then a representative payee. So let's suppose that you get Social Security benefits, and you may not be able to use your Social Security benefits for your own basic care and needs. The Social Security Administration can appoint what they call a representative payee to do so. And nowadays, in the last 5 years, Social Security allows you to designate in advance who you want to be your representative payee. I think they give you 3 choices in order. So that's a very good recent reform. And then VA also has a kind of representative payee, which they call a VA fiduciary, but it's the same idea. And then we circle back to the first question on supported decision making. So healthcare advance directives and financial powers of attorney are surrogate decision-making options. I appoint you to make these decisions for me when I cannot. So you send your voice forward over time. But suppose instead of that you want to continue making your own decisions with help. And let's suppose that you have a network, 3 or 4 or more, or even 1 or 2 individuals who are committed, like in a circle of support, to help you make your own decisions. And this is particularly useful if you're a younger person with intellectual or developmental disabilities. You can make a supported decision-making agreement, and that will be recognized. It's a very new thing. It's still being sorted out, but it's a very important shift in thinking. So the message is plan ahead. Try to avoid, I hope you can't hear that lawnmower. Try to avoid guardianship if you can, but know that if you need it, it's often a very useful tool, especially in a crisis. So that's what I have. I'm, don't know if there's any more questions.
Yeah, we've got a couple. One of them, they wanted you to go back over the difference between conservatorship and guardianship.
Okay, I'm going to sort of go back. Okay, so in Virginia, so it'd be different if you went into Massachusetts or Illinois. It's a little different. In Virginia, we have 2 different kinds of court appointments. One is appointment of a guardian. So the guardian is appointed by court to decide what health care, to make your health care decisions, your residential decisions, your personal decisions, such as who you want or don't want to visit you, things like that, to look at what's important to you. For example, your church might be important to you, so the guardian might be responsible for, making sure that you are able to be involved in your church, that type of thing. Your family might be important, your grandkids. Those are the kinds of things that a guardian would be involved in. A conservator is appointed by the court to deal with your money or property. So let's say you want to sell your house and move in, use that money to move into a nursing home. The conservator would have to sell the house, that type of thing. Now, often, but not always, a guardian and conservator are the same individual, but there could be one and not the other. A guardian could be needed, but not a conservator. A conservator could be needed, but not a guardian. But if both are appointed and they're two different people, they need obviously to work very, very closely together. So that's so the guardian must submit a report to court on the how the person's doing. You know, how is the person, has anything changed in the care of plan since last year? Has the person seen the doctor? Has the person's condition changed? The conservator has to submit an accounting, how the money was spent, what the receipts are, what money is remaining, and how the conservator intends to use it. So if you have, for example, a pension coming in, if there still is such a thing, or anything like that, the conservator would be looking at those funds and how they are used.
Okay. One question you mentioned, in a crisis, how does guardianship happen if somebody's in crisis, given how slow courts tend to be?
Oh, that's an excellent question. Problematic oftentimes. In fact, I'm working on a project now looking at California conservatorship, where one major component is delay. What causes delays in the court process, and what impact do the delays have on the individual? But here in Virginia, we have the ability for the court to appoint a temporary or emergency guardian. So the guardian can be appointed to deal with the crisis, while a more permanent order is progressing through the court, or it may be that the temporary order does the job and the crisis ends, and the person has no need for a permanent guardian. But it's not always that clear cut. It can be pretty messy, and sometimes getting a temporary guardian can be, there can be delays. So that could be a problem. But if it's a real emergency, hopefully and very often a temporary guardianship will be put in place. And then the question becomes, okay, what what authority does that temporary guardian have? It should be authority just to deal with this crisis, because that's what they're appointed to do. But sometimes temporary guardians, you may find them making a broader range of decisions. So that could be a little messy too.
Okay. It's almost 11 o'clock, so, but we have a couple more questions. First one is, how can Arlington residents get more information about guardianship and conservatorship? Who can they talk to?
Okay, so here in Arlington, we're very lucky because the Department of Human Services has what they call a guardianship coordinator. Now, most localities don't have that, and we didn't have that until fairly recently. And that person, if let's say a guardian doesn't turn in their annual report, the guardian coordinator will go and find out what's going on and why. The guardian coordinator will go out into the community and make presentations and help to raise awareness of guardianship and less restrictive options. And the guardian coordinator will review the guardian's reports that come in, and if there's anything amiss, we'll try to bring it up with the court and see if a change is necessary. Now, that having been said, that position recently turned over and a new person has been hired, yay, but is just new on the job, so that's just getting underway again, but we're very lucky to have that position. On the state level, you might want to go to the Supreme Court's guardianship website, and it's doing this by memory, but I think it's guardian.vacourts.gov. And they have a whole range of resources, including steps to become a guardian. They have the link to the guardian training, and they have publications on responsibilities of a guardian. And soon we'll have a brand new guide on less restrictive options in plain language.
Okay. You mentioned payee representatives. How do you go about appointing someone to do that?
Okay, so the representative, the Social Security representative payee is appointed by the Social Security Administration. You don't appoint that person, but recently they made a change such that you can tell Social Security who you would prefer to be your representative payee. You can tell them in advance. These are the three people: my sister, my brother, my cousin. And they will, and unless they find some reason not to, they will most likely appoint that person. So if you have My Social Security account, you'll find on there, part of that site has to do with representative payees, and you'll find an advanced designation for rep payees, and that's where you fill that out.
Okay. A question here: how does out-of-state guardianship work?
Yeah, that can be tricky. So that has to do with jurisdiction. And so usually what we call the home state for guardianship jurisdiction is the state where the person has been residing for at least 6 consecutive months. So if the person lives in Virginia, um, there's nothing wrong with a guardian being appointed who lives in Massachusetts, but it's difficult for that person to carry out their duties. Um, Now, if the person who needs care is in Massachusetts, that will be likely under Massachusetts guardianship. But if the person has property in Virginia, they may need a Virginia conservator. It's more complicated than that, but um, that's basically it. And you possibly may need an attorney in both states, depending on the complexity.
Okay. Have a question. Are attorneys appointed as guardians if there are no close family members? Maybe you could flip forward to the slide you've got that shows the different kinds of guardians, where they come from.
Let's see. Who are the guardians?
There we
Okay.
go.
So it's preferable to have a family member because they know you. They've known you all your life, and they know what's important to you. But obviously, if the family member is abusive or not available, you may need a professional. Or if two family members are fighting, let's say it's a family feud between the brother and the sister, and the court may say, to heck with it, I'm appointing a professional. In Virginia, most of those professionals that the court appoints are attorneys. In some other states, like California, that I'm studying right now, they call them professional fiduciaries. But here, it's usually an attorney, often a trust and estate attorney or an elder law attorney. And so that attorney in the attorney's practice may play several roles. The attorney may represent petitioners. The attorney may represent respondents who are said to need a guardian, and the attorney may serve as guardians. And we have some attorneys who do serve as guardians, and even one state legislator who do serve as guardians over the course of many years. Some states have agencies who serve as guardian, for-profit or nonprofit, and some of those for-profit agencies um, have misused their trust and really have been exposed as agencies that are involved in elder abuse and neglect and exploitation. But here in Virginia, we don't have many of those agencies. It's mostly attorneys.
If an attorney is appointed as a guardian, who pays for the attorney?
So if the attorney is appointed as guardian, the estate of the individual pays for the attorney. And that's why you hear sometimes you hear people saying, oh, that attorney, they're going to drain the estate. And, that's not good. But if the person doesn't have the funds to pay for a guardian, well, that it's possible that the state could pay, but basically, or that they may need actually, let me revise that. They may need to use the public guardianship program if they can't pay for somebody to serve as guardian. And sometimes, unfortunately, sadly enough, the attorney does serve as guardian and does drain the estate, and then the person ends up in the public guardianship program. So all kinds of things can happen, but most of the attorneys who serve as guardians are excellent professionals with high standards.
Uh, question, is the Arlington contact for this information the Office on Aging or Department of Human
It's
Services?
it's Arlington Aging and Disability Services under the Department of Human Services. And as I said, they've just that position has just been made permanent by the county board. Yay! And the person has been hired and is just getting their feet wet.
You don't happen to know the website off the top of your head, do you?
If you go to Arlington Aging and Disability Services, um, you will find it. And if you don't, you're welcome to call me. I mean, I do know the person's name, but I don't think that since they were just hired, I think we should probably give it a little time.
Okay, I think that's all of our questions, and we're well over the hour.
Okay,
So,
well, Erica, thank you for an excellent presentation. As usual, you have provided so much information for us to think about in terms of guardianship and conservatorship. And I did also put the program in which you were joined me as a guest on Aging Matters in the chat. So if somebody wants to check that out, in addition to, of course, this will be included, I think, Gary, on the Arlington Neighborhood Village YouTube page, correct?
yes.
Yes, so lots of opportunities to learn more about this topic. And thank you, Erica.
You all for coming. I appreciate it.
Okay, so next week is another coffee and conversation. The topic will be about music therapy. Leanne Belasco, who is the director of music therapy at Levine School of Music, will talk about ways that seniors can benefit from music therapy and music lessons. So be sure and tune in next Wednesday at 10 o'clock on Coffee and Conversation. And meanwhile, have a good week. And I think the weather's going to be cooler, so it'll be great.